Welcome to The Heart of the Matter, a podcast that covers legal developments from around the world. I'm your host, Stephen Lai. This podcast is brought to you by Conventus Law. Joining me in this episode are Philip Saiter and Viet Laton, lawyers from Vietnam-based law firm Russin Vecchi. Before getting to the heart of the matter, a message from our sponsor, who generously supports this podcast.
Ashford Benjamin was founded with the belief that search firms should offer a better service to clients and candidates. This means taking the time to provide a genuine partnership, understanding our clients' and candidates' needs, and proactively advising on the best course of action, utilizing the decades of experience in our industry specialisms, including risk, compliance, business and legal recruitment consultancy, located in central Hong Kong, serving Asia Pacific.
Hi, Philip. Hi, Viet. How are you?
Very good, thanks. Good to see you, Stephen. Glad to be back.
Good, thank you, Stephen.
Fantastic. Well, great to have you guys on the show. We're going to be talking about Decree 13, Vietnam's latest data protection framework today. Starting with you, Viet, can you tell us what are some of the key changes in Vietnam's data protection framework introduced by this Decree 13/2023? And how's that different from Decree 53, which we talked about on a previous podcast towards the end of last year?
You can call this the Decree 13, the 2023, just the number of this year. So this Decree 13 is like the first attempt of the government in consolidating all of the previous rules and regulation on data protection. It also try to update the Vietnam's legislation to be more compatible with the international rules on data protection, namely the GDPR and others. So there are a couple of new things in this Decree 13. First is a very detailed description of the type of data that is considered to be personal data. Second is a more clarification in terms of the roles of the parties involved in the data processing activities. And third is additional requirement in terms of government control over data protection in Vietnam. I think we can share more details when later in this podcast.
Great. You mentioned more compatibility with international laws or the GDPR, etc. So when it comes to collection, storage, processing data, how does this impact businesses operating in Vietnam, or perhaps to the point of this question, or businesses having activities in Vietnam from outside Vietnam?
I think we should mention that the scope of this Decree 13. This Decree 13 is quite a large scope. So first thing is it applies to anyone or any entity being physically in Vietnam, regardless of nationalities. Second is that it applies to anyone who process the personal data in Vietnam, so regardless of location. And third is that it applies to foreign individual and entities involved in the data processing activities in Vietnam. At first glance, it seems like the Decree 13 tries to include everyone that is involved with personal data in Vietnam, but there are still some ambiguity in terms of what type of involvement so does the foreign individual and entities needs to have in the data processing to be covered under this decree. I think that the government will try to clarify on this point further on with additional documents.
What's quite noticeable is the data protection laws in many different jurisdictions around the world is they all have quite a big scope when it comes to processing data in their own jurisdictions, even if you're outside of that jurisdiction. But the question is enforceability. So, obviously that's also going to be quite hard when a business is not physically in your jurisdiction. I would imagine enforcement of that will be quite difficult. Does it rely on a lot of good faith on the parties for Decree 13 to work for overseas businesses?
Yes, so it seems that I think I can understand to some extent what the government is trying to do with this Decree 13, because in many of the requirements that we will talk about later, that the government tried to limit the amount of personal data that foreign entities can get access to. So that, for example, if you look at in order to transfer the personal data of Vietnamese national offshore, you will need to file certain documents with the government, and I think they try to control it that way. But in terms of enforceability, the government they said that they will have like a separate document regarding sanction and violation later. But even with the framework for sanction and violation, is the question of enforceability is still up there.
How does the legal framework define and regulate consent as a legal basis for processing personal data? What are the requirements for valid consent? And are there circumstances where consent is actually not required?
Hey, Stephen, I'll take that one. So we have a three-part question here. Let's just unpack it one step at a time. So for the first part, consent in under the Decree 13 is defined as it's required to be voluntary and informed. It has to be express and specific, verifiable, and it can also be partial or conditional. So there's a lot going on there. Voluntary and informed means that the data subject needs to be aware of the types of personal data that are going to be processed, the purpose of the processing, who specifically is permitted to process, and their own rights and obligations, right, of the data subjects themselves. Also, whether or not the data is considered sensitive. So there's a distinction between sensitive personal data and personal data. The element of being express and specific, it means it has to be expressed specifically in writing or voice recordings. There has to be some kind of a express action. So like tick a box to agree, a text message, something like that. It cannot be a silent or like a non-action, like an implied consent. In other jurisdictions and here prior to this, you may recall seeing websites where there's no pop-up, there's nothing that requires you to actually have a physical or explicit action to consent. It's just you click on the terms and services, and somewhere in the language it says, if you use our website, you agree to our terms, or you agree to your personal data being shared or processed, right? So that's expressly not the case in Decree 13. Verifiable means that the consent must be in a format which can be printed or copied, including electronic formats. Consent can also be partial or conditional. So it means that the data subject is not required to give consent to everything you're asking for. They can consent to parts of it. Some part of it could be conditional upon, some change in circumstances. Now, I mean, this is theoretically, right? In practice, we're not sure how this will actually play out. It's an interesting subject to follow, and let's see how it'll play out. But in theory, anyways, consent can be partial and conditional.
I go into different websites from different jurisdictions. A pop-up always comes up and said, "Oh, you consent to allow cookies," or you disagree, or you could go to settings. Is that what you're talking about there?
Yeah, something like that would, of course, the language would have to be appropriate. But yeah, I mean that would be an express and specific action. like that would be ticking a box.
Yeah.
You know, if some language pops up, at least they have the opportunity to read it. They have to check a box that would apply. But just having some assumption of consent would not be enough. So the third part of your question, you asked if there were circumstances where consent would not be required. So there, yeah, I mean, the decree allows for emergency scenarios. You know, immediate processing of data would be required in a case to protect lives or health of the data subject or other individuals. A situation perhaps where, you know, there's a threat to national security, something like this, or natural disasters, you know, or there's kind of a broad catch-all that says to support the activities of authorities as provided in any sectoral law. So that could kind of leave a door open to the authorities processing personal data if required without consent.
And I guess from a company's perspective, how much clarity is there on that, on the sort of the non-consents versus compulsory consents?
Well, I mean, so far it seems relatively clear in the language that, you know, this doesn't seem like one of the ambiguous areas in this decree. This is quite clear. You know, they have the elements laid out clearly. This is what's required. So I think from that standpoint, it's relatively clear.
Data privacy law in Vietnam, I think we've seen a lot of activity, I think over the certainly over the last 12 months. How does the data privacy law of Vietnam define and regulate the rights of individuals in relation to their personal data, you know, such as rights to access, rectify, and perhaps most importantly, deleting personal data held by organizations?
Yeah, I mean, the decree does, it specifically sets out the rights of data subjects. So you have a whole kind of a laundry list of rights. Some of them you've mentioned, right? The right to access, right to rectify and delete. They have the right to know about the processing activities that are taking place, you know, that are happening with their data. They have the right to consent, like we just mentioned, which has its own, you know, they have the right to give consent. They have the right to withdraw consent. They have the right to delete or to request to delete data if they no longer wish to extend their consent. They have the right to claim for damages if their data is being misused or if they're being abused somehow, and they're able to make legal claims, right? They can start a legal action. Yeah, and they have the right to access, and there are they give kind of the basics for, okay, this is there are procedures available. This is what you do if you want to, you know, withdraw your consent or if you would like to have your data deleted.
If people forget how young this whole internet industry is, right? I mean, it was only, I mean, I remember it really only started as an industry in the early 90s, and it really only got popular in the mid noughties. So we're only talking really in reality 20 odd years of a young industry. And I think in that space of time, the sophistication of the individual consumer has also grown, you know, exponentially over that period. I mean, I think before, when the social media platforms first came out, everybody was just signing off the data, you know, without any thought of the issues that we're talking about now. So I guess with the more knowledge, the more savvy the consumer, I guess the laws, it makes sense to have these to give them the rights.
Yeah, I agree, and I think also on the flip side of that is the technology always advances faster than the regulation, and so it takes some time, and then, you know, the regulators start to see also, okay, look, there are actual real threats here. There's so much data out there now. There are all these potential vectors for attack, right? And they have to do something at some point, right? So these are interesting times indeed.
Which regulatory body is actually responsible for overseeing and enforcing with the compliance with the data protection laws in Vietnam? And well, what powers and authorities does this regulatory body have? And, you know, I guess the question is really how strong are they? How much teeth do they have?
So it is interesting that, like, if you look at the previous regulation on data privacy, you will see the Ministry of Information and Communication comes up a lot. But since this Decree 13, the government has shifted the responsibility regarding data privacy to the hand of the Ministry of Public Security. So it might seem that like in terms of idea, I think the Vietnamese government consider this more of a security threat than a commercial one. And under the Ministry of Public Security, they have a department on cyber security and prevention of cybercrime, which will be like the main regulatory body on this topic. They will be the one that you report data breach to. They will be the one that provide you with guidance regarding the multiple reports that you have to file or the data impact assessment that you need to file. And they will also be the one that will implement the sanction or other types of action regarding your activities in terms of data protection in Vietnam. This Decree 13 also mentioned that the government will have like a central hub for the regulatory body and the data processor and data controller to interact. And it will be online on the national portal on data protection. But so far, the portal has not been published by the government yet, and we are still waiting for its availability.
Moving on then, mainly focusing on the obligations of organizations and other businesses. Under this Decree 13, what are the criteria and obligations of an organization to qualify as a data controller, and what are their primary responsibilities?
As I have mentioned before, so like this Decree 13 has some resemblance to the with the GDPR in Europe. The concept of data controller is one of those that are adopted from the GDPR. To be clear from the start, there are multiple parties involving in data processing that this Decree 13 covers. One is a data controller, the other is a data processor, and the third is like other third party. The government also mentioned that a party can be both the data controller and data processor at the same time. However, when we talk about a data controller, the defining criteria is that this is the party that will determine the purpose and the manner for data processing activities. So like if you decide that you need certain data to be processed for marketing purposes, you set that up and you hire another party to do the actual processing for you. And in that case, you will be classified as a data controller in Vietnam. Basically, this data controller is like the contact point between the data subject, the government, and itself. If the data subject has any requests regarding their rights, the request will be forwarded to the data controller. If there is a data breach, it is the responsibility of the data controller to make the report to the government and not the data processors. There are others, other responsibility, but they are pretty much basic, such as the data processor needs to have like certain security measures and certain technical and management measures in terms of protecting the data that the personal data that they have access to. And because a data controller main interaction with the personal data is through another data processor, the law also requires that a data controller must only work with data processor that have like the appropriate security measures to protect the personal data that they process. So one of the responsibility of a data controller is to perform a due diligence on their partner, the data processor.
It sounds like there's a lot of work then. Presumably the organizations are going to have some sort of, I guess, procedure in place, and presumably that they're liable for audit at some point for this stuff. Will it get to a stage where every organization who operates in Vietnam, do they have to give out a responsible person, a responsible officer within the organization, and publish that on their website, or if they're a listed company, they have to publish it on the public domain?
I think it's a good practice that everyone should have one, so like a data protection officer. But like this decree 13 only requires it if a data controller or the data processors so like have access to sensitive personal data of a person. It's not required for everyone.
So it's good practice, but not compulsory right now.
Yeah, it's only compulsory if you have access to sensitive personal data.
Right. Okay. Thank you for clearing that up. Well, you're quite detailed there. You actually talked about the specific obligations and responsibilities of the data processor already. So I'm just going to skip on to the next question. Can you maybe explain a bit more about the role and the significance of conducting a data protection impact assessment mandated by this decree, and what factors or circumstances trigger the requirement of the data protection impact assessment, DPIA?
The data protection impact assessment statement. This is basically, it serves to ensure that data controllers and processors are, they're acting compliant, that they're following the rules, and it's, of course, ultimately it's to safeguard the rights of data subjects. It's triggered by basically anyone who's processing data, or if you're sending data offshore, right? So there are three different kinds. There's one for the controller, one for the processor, and one for offshore transfer. As Viet mentioned earlier, there are circumstances where an organization or it could be doing both, acting as a controller and a processor. And so far, we know that in that case, they should file the dossier for controllers. So again, I think this was mentioned earlier that all of, we're still waiting on the guiding document, and we're still waiting on the national portal on data protection to go live. That will clarify all of these administrative procedures on the submission of these data impact assessments and other things like notifications and data breaches. But yeah, so both data controllers and data processors, they have to conduct these personal information impact assessments for all of their processing activities. So for basic and sensitive personal data, if they do it themselves, or if they're contracting a data processor, providing information to third parties, or transferring data overseas, I believe they must be submitted within 60 days of commencing the processing activity. So it doesn't have to be done before, but it has to be submitted within 60 days. Just to clarify here, this isn't for every time you process data, right? This is like, one kind of organization wide, we have to submit this impact assessment to make sure that, everything is being done correctly. And so far, I think generally we understand that these impact assessment dossiers have to include, information on the data controller, the data processor, their internal data protection officer, if they have one, who are the recipients and the nationality of these recipients if data is being sent overseas, types and purpose of personal data processed, retention periods, and there's a kind of a risk assessment and mitigation component, right? So what, within our internal processes, like where are the potential risks, what are we doing to mitigate these risks, and so on. And as you commented rightly earlier, yeah, I mean, it looks like there will have to be some opportunity for audit as well. So
the DPIA, it sounds like an audit, but am I right in saying though, you don't need to proactively have a audited processing in place, but you only need to do it if called upon to do this, and you've got 60 days to complete it. Am I right in saying that?
Well, from what I understand, and again, I mean, the procedures that we're still waiting on clarification, but it seems that these assessments will be submitted to the national portal that we haven't seen yet. It's not live yet, but then there is also, it appears, a requirement to sort of, be ready in case the MPS asks to see it, right? So there's this kind of audit function, and then also you need to be able to update and supplement these things in case anything changes.
So I guess back to Viet was saying before that obviously if you want best practice, you probably want to have something in place now. You have it ready, good business practice, but
Yeah.
essentially it's not compulsory.
Well, it depends. It's compulsory if you're transferring data overseas. It's compulsory. I mean, these are required if you're processing personal data, if you're processing sensitive data. But yes, I mean, especially when things are a bit up in the air and we're still waiting on further guidance. Yeah, I think it's wise to implement best practices and be sort of ready for all possibilities.
Well, that's actually we talked about the sort of bird's eye view of what needs to be done and who's in charge and who's regulating. Specifically, what are the requirements in connection with cross-border transfer of personal data? Are they like more detailed nuances involved that businesses actually need to know about?
Cross-border data of any Vietnamese citizens has to be accompanied by this transfer impact assessment.
Right.
So yeah, it kind of just follows from what we were just discussing. It's information of the transferor and the receiver, description of the data to be transferred, description of protective measures applied in case there's any kind of risk of data leak and so on. Yeah, it's supposed to consider undesirable consequences and damages that could occur. And there should be some provision for measures to reduce or remove these kinds of consequences. Of course, consent, right? Was consent obtained for this cross-border transfer? This is kind of a very important key point. And then it should include also a document that binds the transferor and the receiver. It's like a data transfer agreement. So if you're sending some data subjects data overseas, there has to be an agreement in place between the transferor and the receiver.
Now I understand Decree 13 came into effect. Did it come into effect 1st of July, I believe? It did just earlier.
Correct.
Early days. So I would imagine there's a lot of businesses running around trying to get their houses in order to be compliant to Decree 13. Before we leave, I want to ask Viet and yourself if there was some tips that you would give a business about how to get to the best practice and be compliant with Decree 13. What would it be? Starting with you, Viet.
You have mentioned before, like a business should understand what they are doing with their personal data and who they are interacting with in terms of collecting personal data and processing personal data. And in doing so, I think one of the best way is just to perform a audit of their data practices. So like they can do it themselves or they can hire another party. But I think the point here is that they need to understand like what type of the personal data they are working with, what type of third party they are dealing with in terms of processing personal data, because many of the requirements under Decree 13 is conditional upon certain activities you do. For example, if you process sensitive personal data, you will have different requirements from if you only process like basic personal data. And if you are a data controller, you have different responsibility from a data if you are a data processor. So I think the most important thing is that the business should understand their own data practices. This apply to both customer data and the personal data of their employees as well.
Right. And Philip?
Yeah, I mean, I think what just to kind of follow from what Viet said, it's tough to be compliant when you don't know your starting point, right? I mean, there can be all kinds of compliance gaps that an organization is just likely unaware of, right? Because first you need to understand your baseline. Where are we starting from? And without conducting a data audit, for example, it's pretty difficult, I think, to understand, especially for organizations that have multiple channels where they're collecting data, right? Whether it's online, in person, I mean, in this day and age, data is coming, it's like this flood of data coming into organizations, right? Especially ones that are interfacing with many customers on a regular basis, right? So yeah, I think what Viet said is it hits the nail on the head. You know, these organizations should be looking inward, doing an audit and identifying potential compliance gaps, and then taking measures to right the ship where needed.
Fantastic. And with that, time's up, gentlemen. Thank you very much for joining me on this podcast and shedding light on Decree 13. Very, very interesting indeed. Thank you, Viet. Thank you, Philip. And I look forward to speaking to you very soon next time.
Fantastic. Thanks for having us.
Thank you, Stephen.
And thank you, listeners, for listening. I look forward to talking to you on our next episode.